Welcome to today's video. We've got two clips to cover. First, a disrespectful man-child getting completely manhandled by an incredible judge. And second, someone who just realized they can't actually ignore their credit card bill. Before we dive in, a quick shout out to Ground News, an app and website that gathers news from around the world in one place. It shows the political leanings and factual accuracy of each article, giving you the full picture. For example, recent coverage of a dust storm in Phoenix was 95% from highly factual sources, 58% from the center. One useful feature is the blind spot tool, which highlights stories reported heavily by one side, but ignored by the other. This helps you avoid falling for biased news and stay fully informed. You can check out Ground News by visiting their website or scanning the QR code on screen to get 40% off the Vantage plan and access all features. Thanks to Ground News for sponsoring today's video. Now, let's jump into the first clip and see what happens.
Watch your step. Good.
Case number 25S00791. FY, People State of Michigan versus Timothy Dansby.
Second on behalf of people.
Illinois, P87446, Stephen in for the attorney of record, John Dominic, and appearing on behalf of Mr. Dansby, who stands to my right. Mr. Dansby, can you please state your full name for the record?
Yes, my name is Timothy Dansby, and I can represent myself and I'll take counsel as an assistant, you know. So, I don't know who this being there. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer?
You
don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork. I haven't received my discovery back.
Well, that's what we got lawyers for, sir.
To the count machine to get to the lawyer very well to the county. So it's paying me hard. So I'm gonna need some type of system.
Okay, well, that's what we got for you. Okay.
I'm gonna be representing myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
So first is I want to go ahead on with the preliminary.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge, let's see.
I believe it's 5 years.
Yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain to go with you.
Well, you can have but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. So if nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying.
I'm gonna go out on a limb here and say that even though this guy has 2 ears to listen, he's still lacking the brain to process what you're saying. But that's just my observational opinion.
All right, so this charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing, where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed it. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. All right. So you understand all that? Now you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Dansby today, and have not received any audiovisual discovery from my understanding.
I like the ground if you don't mind. Part of motion, you know what I'm saying, for the fact that I have been denied, you know what I'm saying, in the time denied. You know what I'm saying, and the prosecutor was conduct, we should be my government training, even though in my
Okay, that's a lot of talking. Where's the prosecutor? Yeah, but where's the prosecutorial misconduct?
Well, I should have had my discovery, y'all.
Sir.
I'd say this guy might have 2 ears to hear. but he's clearly missing the brain to actually process what's being said. That's just my observation, though.
Do you understand how this process works? Well, no, you shouldn't have had your discovery because this is the first hearing.
So in the first year, I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just like, oh, yes, come on, this is not slavery. This is not the one, I am not the one. I don't care nothing about the United States. First of all,
apparently not. You must not care too much about anything, sir. Okay.
I don't even have a license. What's your license for?
First of all, I don't know who you think you're talking to. But do you want to spend an extra 30 days in custody? No, you don't. You don't care. That's why you're here charged with something.
What is your license for?
I don't have to answer you, and I don't answer to you. And I'm not going to start now. You need to settle down. You need to settle down. Okay, take him out of here, please.
You'll receive all the discovery as soon as the prosecutor provides it, just like the judge mentioned.
That's okay. He's having his moments. So we're going to adjourn this, and I'm going to waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right, so we'll give you, what do you think? You could just need video?
Understanding, yes.
Okay, so we'll give like a couple weeks to do it.
Yes.
And he's going to want to see it, so you're probably going to need to have him take the laptop over there to the jail and take his license to practice law to it.
Yes.
Okay. All right. So the next probable cause conference on this charge is going to be.
I just, to make a record as regards to that discovery, I do have paper discovery, which Sister Counsel has noted that has been tendered already. I do not have, does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
August 25th at 9:30, and hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Dominic will be in trial in the Wayne County Circuit Court. I can make that they work for myself if you're wanting Mr. Dominic to be here.
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance that I would feel more comfortable with Mr. Dominic because he handled his own.
Well, you know what? You got to cut your teeth somehow. We've all had this.
Just don't know.
Ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got this race right. I know that he's an expert in this.
I've had my share over the years when I was licensed to practice law. So. By his standards, I'm not licensed. Okay. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more settled down.
All right. The judge sent the inmate back home, but took a few minutes to speak with the defense attorney. I'm including this part because it's a reminder that even experienced attorneys once had that one difficult client when they were starting out.
This is case number 25S00791FY, People State of Michigan versus Timothy Dansby.
Chuck, on behalf of the people. Morning, Your Honor. Thank you, Donica. Heard on behalf of Mr. Williams.
Okay, Mr. Gonick, good morning. Sir, come on. Can you get up? Can he move? No? Okay, sir, can you tell us your name? All right, so Mr. Dansby, today is the adjourn date for a probable cause conference on this charge of this was a retail fraud, first degree. And so last time, Mr. Gonick, you needed some video discovery and you wanted to review all that. So did you get a chance to do that? Okay. Well, he didn't apparently, but did you look at it?
I did not receive it.
Okay, what happened with the video discovery?
I wasn't here in this case.
Huh?
I don't see it even in my file, so, what you can tell the court is, actually, this is next day, so I'll get it today instead of.
Oh, all right. Well, things might have slowed down since she was off. Okay, so you want an adjournment, Mr. Gonick, again? A brief one? I don't know. How long would you like?
Pardon me?
How long would you like it to be?
We have a trial next week starting in front of Judge Rowe, but it's only going to be a couple day trial.
Okay. Okay, sir, put your hand down. Put your hand down. Okay. The following week.
Yes.
What do we have the following week? Not next week, but the following week.
Or just another
Another PCC.
for 8th at 9:10.
How about September 8th, 9:30? We'll get to you in just a second, sir.
The only problem I have is that my trial starts on the 4th. It should be done the 5th, but that's Judge Rowe's criminal call, so that'd be
So he won't be doing it during that.
trial.
Yeah.
Right. That would be.
September 8th at 9:30 then. Now, what do you want to say, sir?
Say, guys, that, first of all, this is supposed to be an examination, but I'm not asking for the German. I'm asking for more. I also want to say this lawyer is being forced on me, because I can ask for one. I didn't sign for no attorney to be represented, so I don't know why he adjourned something where he's not even, I don't even have him to represent. I mean,
How you going to get the information?
I don't get the information, well, I said, apparently,
Sir,
bring to me and review it.
okay, the prosecutor ain't going to bring nothing to the jail to review.
About what the law says. I'm going by
Okay.
what he did.
I don't know what law you looking at. Okay, but the prosecutor's not gonna bring you.
But I'm an inclusionary member of the bar by the Constitution of right. I have the right to be free and prosecute myself by the Constitution of the United States Constitution, which is the highest law of the land. Courtroom.
All I could take from that jumble of words was that the Constitution of the United States somehow overrides court procedure. Honestly, this is the first time I've ever heard of the Constitution of the Constitution. So let's see where this imaginary document leads us.
I also know that these individuals, I don't even know if these individuals are even practicing law. I don't even know if they like to practice law.
What they're doing don't matter. They're not on your case, sir. Sir, I'm not trying any facts. Okay? Number one.
Represented by legal lawyers, not persons impersonating lawyers.
Okay, stop. You finished now?
No, I'm not. You're supposed to stop. I'm not finished.
Okay, well, you're finished as far as I'm concerned. So this is what I got to say to you. First of all, we don't allow anyone to practice law that's unlicensed.
That's not true.
Okay, let me just, I don't do it in this courtroom. Okay, sir, would you stop talking to Wolf? I have to have you taken out of here? Because you don't listen. You don't listen.
I have a constitutional right to represent
Charles.
Sure.
Now, what I'm trying to tell you is this. The prosecutor can't bring you a video. And the video could be the crux of the case. We don't know what it shows. Your lawyer would be derelict and the person here, this the lawyer that's here that's been assigned. Okay? So he would be derelict in duty if he didn't get it, to look at it, and to try to ask. Well, he doesn't have it yet, sir. And then he can ask, and
I'm asking for this due process.
okay, first of all, There's no basis. There's no
In a
basis.
timely manner.
The motion's denied. There's no basis to dismiss the case. Okay? Not right now, there is not. And so he can ask to bring his computer into the facility to show you the video. If he gets it, which apparently the prosecutor didn't have it. This is the normal prosecutor.
Lying on me.
Okay.
I'm like, let's try what for the court.
Okay, well, I'm just explaining to you. I don't know who lied or who didn't.
He got money, never got one because they never intended to go this far. They didn't think that I was going to go this far. They think that I'd come back down.
Okay. Well, guess what?
Take no plea to something I did not do.
Nobody asked you to take a plea. First of all,
I'm telling you what he asked.
he might ask you if you wanted to. I don't know what he said. That's between you and him. But the bottom line is, he doesn't even have all the information to make a determination.
But they asked me when he
Okay, I don't know. I said I don't know what he asked you. That's between you and your lawyer. I don't get involved with that.
Yeah. Conversations between you and your lawyer are meant to be private and confidential. That's how it should be. But if you choose to represent yourself, then I guess the only conversations happening inside your empty head should probably stay there too.
So what I'm trying to tell you is nobody's trying to get you to plead, at least not here, because I'm not taking a plea on this particular case, even though I probably could take a felony plea. I'm not doing that. We're just here to see what's going to happen as far as the discovery and if we need to hold a preliminary exam or not.
not going to, and it's not going to be, it's not going to see it, because this is supposed to be my examination. It's not,
This was not your exam. This was a probable cause conference date. All right, we haven't set the exam yet because we haven't gotten all the information to set it. So we're going to go ahead and get the information and we'll make a determination if we're going to set it just in the next week when we come back. So that's what we're going to do. And you need to calm down. Okay? Violence continue.
I'm trying to be right. I already know I get a little animal.
Yes,
That's when I know that I have been
but then the truth will come out.
about none of that, because these people are trying to prosecute.
The truth will come out, sir.
And I'm not going for it.
Okay.
Go ahead on with that.
All right.
Thank you.
We thank you. All right. Fine. Continue.
Adios.
We'll see you back here on the 8th, 9:30. That's another PCC.
All right. That wraps up the second hearing. But he'll be back in a few weeks to disrupt the court again and pour more of his poor me nonsense all over the record. Next, we move to Judge Goggins' courtroom, where a sovereign citizen appeared yesterday. Someone who apparently only recently woke up from his nightmare of credit card debt. I'm guessing it happened after he read online that you can just wave a magical sovereign citizen wand and make your debt vanish into thin air.
Order. Mr. Jamal, let's just do your second one, your Citibank versus John Hayes.
Yes, and good morning, Joseph Jamal here on behalf of the plaintiff.
This is file 2425, and I've got another gentleman here, John Michael, who apparently has filed paperwork.
Yes.
Mr. John Michael, you've got semicolon Hayes, respondent. First of all, are you an attorney?
I am not.
Okay. So do you have, you're alleging in, I guess, all these documents that you're somehow a representative for John Hayes. Is that right?
That is correct, sir.
So how are you, or it says beneficiary, do you have some paperwork giving you some authority to act for John Hayes today?
The UCC 1 that was filed.
But no, is there an order, court order? I understand the rules and the statutes and the laws, but do you have anything that says, listen, you've got authority?
I have nothing other than the process of the United States Corporation
I
that
see.
committed started the trust in my name.
Who started the trust in your name?
The Corporation of the United States of America after its bankruptcy.
Oh, you went through a bankruptcy?
No, the United States of America, the corporation did.
Oh, I got you.
19.
So but you have nothing that says you can represent John Hayes then.
I'm not acting as surety for John
Okay.
Hayes, that is for sure.
All right, so we've got a motion to dismiss. I don't have an attorney that's filed a motion to dismiss. I guess, Mr. Jamal, let's hear that first, I guess.
Your Honor, I guess my understanding, you said motion to dismiss. Is that for plaintiff's motion for summary
Yeah.
judgment you're referencing?
Well, you've got your summary disposition motion that's out, but he's got also, it looks like his motion to dismiss, defendant's motion to dismiss. That's one I think is probably easier to deal with first.
Okay.
I don't even know what it, quite frankly, it is, but you did respond to it, it looks like. Plaintiff's response to defense motion to dismiss. Anything you want to tell me on that one, I guess?
Nothing further, but for the fact that, based on my understanding of the court rules, everything was filed as required by the law. No actual documentation is required with the notice pleading state, of which Michigan is. Notice was provided since we have provided detailed account documentation supporting our claim. So I think his motion to dismiss related to failure to state a claim and lack of subject matter jurisdiction should both be denied.
Okay.
I object to
And
the-
Mr. However you want to refer to yourself, John Michael.
I believe his name is John Michael, from the Cologne Sniffer family, and a proud beneficiary of some truly terrible advice found online. Say yes, sir, if you agree.
Okay. What did you want to tell me about your motion?
Well, I asked all of the parties involved for validations, and I sent a statement of facts, and none of which were responded to, so that would be acquiescence to the truth of my statements, which should stand in truth and commerce. I asked for a contract and demonstration where there was adequate consideration giving, and did not receive any of that. It's my understanding that the consumer credit transaction or the application was taken by the Citibank and Best Buy to securitize the collateral to the Department of Treasury for their funds. They were paid, and now they're asking for me to pay in addition to that. I did not realize any of this was true until recently. And now if I am continuing to be required to make payment in any form of negotiable instruments, they are, in my opinion, are being unjustly enriched. They have never given me a contract with a signature. They've given me valid verification by bills and statements, but never anything that would demonstrate that they ever had anything at risk or that they lost anything. Therefore, without a contract, there is no standing, there's no claim to bring remedy to.
You find there's been significant number of documents that have been filed, one being the motion to dismiss this matter. It's signed John Michael, Hayes beneficiary. I've got no indication that John Hayes, whose pleading this is filed against, is in fact here. I've got no attorney representing John Hayes. I've got some allegations that John
Sir,
Michael,
I do not
hold on, sir, it's my turn. Sir, it's my turn. John Michael is somehow representing John Hayes. That's one problematic point with the motions that were filed. It's got a notice of special appearance, but I can't have a special appearance without some authority from John Michael. I did get a chance to review nonetheless all the documentations with regard to the motion to dismiss. I reviewed plaintiff's response to that defense motion to dismiss. I do find there's a significant amount of documents that have been attached regarding this account that alleged to have not been paid. It's a credit card account of some sort. All of the addresses match up to the same John Hayes at the same address, 5141 Flagler Street, Flint, Michigan, 48532. Statements were going to that address. I see the card or the account was used on that occasion, so throughout the documents that have been supplied. Also find that there were some payments made on that account as well. Therefore, based upon all of the evidence at this point, based upon this motion to dismiss, that motion is denied.
Well, It seems the bad advice he found online didn't just cover how to make debt disappear. It also included tips on how not to win a dismissal in court. Now, let's hear from the plaintiff about the details of this attempted credit card fraud.
And now we're on plaintiff's motion for summary disposition based on MCR 2.116. Is it a C9, C10? I guess I gotta look. C9, C10 motion. Mr. Jamal, this is your motion at this point. What, on this motion, did you receive a response to the motion for summary disposition?
I did receive a reply from the defendant. That was somewhat recently. I'm not sure if the court has that in the file.
Okay, I got it.
It's titled the reply. Let's have it opened here.
You should have it since it was filed at the courthouse.
What's it titled?
It's titled Respondent's Reply to Plaintiff's Response to Defendant's Motion to Dismiss.
Oh, I got that one.
Okay, that's the only one I see.
Okay. Mr. John Michael, is that the only response to the motion for summary disposition?
You asking me?
Yes.
Yes.
Okay. All right. I've got that.
That was the last response because that was I have not received anything more from them.
Okay. All right. So I've got that in my hand as well. Mr. Jamal, you can proceed with your motion.
Yeah, so the motion is primarily based on 2.116C10. Included with our motion for summary, we've provided detailed account statements that breaks out the usage of the account from a zero balance to the balance we're seeking in our complaint. We show not only usage, but also payment made towards the account. Those statements were sent to the address we currently, I believe, service was made to defendant at. Given those facts, we are seeking a motion for summary be granted in the amount as requested. And I would just indicate too, defendant has referenced seeking a wedding signature, additional contract terms, etc. However, usage of an account constitutes agreement for liability on that account. These statements specifically indicate that this account was sent and used without objection by defendant, and therefore liability should exist.
Okay. And the amount, it looks like, just on I don't want the court cost, but it looks like the damages for the card, the account itself is $2,349.65. Is that the right amount?
That is correct, yes.
Yeah. All right.
And that should be supported by the last statement we have included in our packet. Also has a balance of $2,349.65.
So let's see that here. Way in the back here.
The payment due date on that statement is February 17, 2025.
No, thank you, Jamal. I was just looking for the last. Here it is. Yeah, I'm sorry, February 17, 2025. That's the last one I'm seeing. Yeah.
He applied for the credit card, received it, and even made previous payments. And that alone establishes a binding agreement between both parties. If he had never used a card or made any payments, then he might have had a valid argument about whether the credit card and its debt were legitimate.
Okay. Mr. John Michael, any response?
Well, my paperwork should stand on its own. There was billing statements are self-generated and lack foundation, and are inadmissible as live testimony and of a custodian with a personal no one of personal knowledge under MRE 8036. Prior payments do not establish a contract liability. My realization of the fact that the Citibank, Best Buy, and or the law firm have provided any adequate compensation to complete the contract. And nor did they express the fact that they were changing my standing from the creditor, because it was my credit worthiness that created the substance for the loan. They were paid. That was basically conversion from me, from the creditor to the debtor. Under trust law, it converts my standing from the beneficiary to the trustee. And I affirm that there is no standing that they have to file a claim against the living man. And if you're refusing to...
Mr. Michael, from what I hear though, you're acknowledging that this is your account.
I am not acknowledging that it is my account.
Well,
No,
you just
I
said
am
that
not.
they used your credit standing to form the basis of the contract originally.
Yes, that is
Yeah,
true.
so how are you not?
Therefore, if it was my financing, the credibility that funded this loan, how do I owe them any money?
Because you used the credit card. That's how.
Sure, I quite understand, Mr.
I'm
Jamal.
not hearing you.
The only response I would have, Your Honor, is he does reference admissibility. I think Michigan law is pretty clear that when it comes to a motion for summary, documentation is admissible to the extent that it would be admissible at a trial with proper foundation being laid. Foundation does not need to be laid at the motion for summary stage. There is no need for testimony or additional authentication. So the statements are properly before the court at a motion stage.
Okay, I'm just going to take a brief recess off the matter. I'm going to review
May I
the
make a
statements that have been
comment?
supplied. No, nope,
May I
that's it.
make
We're done. Nope, I'm going to make a decision.
They
Hold
don't have
on.
it.
I'll
They
be
don't
right back
have a
on.
lawful contract.
Sir, you told me that already. I'm going to take a brief recess. I'm going to review all the pleadings in its entirety, and I'll come right back on. Okay, we can come back on the record with Citibank versus John Hayes. I've had a chance to review all the pleadings and documents that have been provided by both sides. This matter. This is a motion brought in part by MCR 2.116C10. This motion may be granted where there is no genuine issue of material fact and which would entitle the movement to a judgment as a matter of law. In determining the factual support for this claim, I have reviewed all of the pleadings, affidavits, any depositions, admissions, and other documentary evidence that's been provided today. It should be noted that the non-movement party, that being John Hayes in this matter, does not rest merely on allegations or denial of the pleadings, but also must demonstrate by documentary evidence that there is a genuine issue for trial. I do find, after significantly going through all of the documents that have been provided to me today, the consistency of the statements that went out, starting with a new account through Citibank on this account, and this account was, let's see, where is it? Card ending in 8271, John Hayes. You find that there was this card was used over a significant period of time. There were also payments made over a period of time. The address was sent, all of these documents were sent to, these statements were sent to John Hayes at 5141 Flagler Street, Flint, Michigan, 48532. Do find it's consistent with what's been complained of, the amount owing. The final statement that has been complained of today, February 17th, 2025, shows a balance owing of $2,349.65. Find based upon all the documents, all the pleadings, there's no genuine issue material fact. Grant motion for summary disposition to Citibank for damages $2,349.65 plus court costs that are being requested. Mr. Jamal, I thought I saw somewhere in here.
There was a proposed judgment submitted with the motion.
Okay. Just gotta find it.
Everything's still in order. It's typically page 7 or 8.
If it's still in order, does that mean I may have tore it apart? Is that what you're telling me?
Potentially.
I'll find it here. It's probably the last page.
If needed, I can email it.
Do you have the figures in front of the court costs?
I do.
What do you have?
Filing fee of $75.
Okay,
Motion fee of $20.
okay.
Service fee of $58.68.
68.
Total is $153.68. Add that to the damages amount referenced, and total balance is $2,503.33.
Okay. Oh, here, and when you know, I found it right at the end. There it is. I do have the proposed judgment showing the amount I asked for damages originally, the total on February 17, 2,349.65, plus the court cost is just recited for a total of $2,503.33. Judgment for plaintiff in that amount based on summary disposition. MCR 2.11610. I'll sign that proposed judgment and send both of you a copy. Okay?
Thank you all.
All right. Good luck to both of you.
I object, Your Honor.
Okay.
I'd like to make a comment that you're making a judgment based on no contract. All the 6 requirements of a contract were not met. I came to the realization that there was no consideration and no risk and not full disclosure. And you're still going to judge against that without a contract?
I'm not taking questions, sir. You can put your statement on. Is there anything else?
I let my paperwork stand again, and I will have to file for an appeal under Article 10 of the Constitution. This controversy is greater than $25. I will be filing in the Court of Appeal.
File an appeal if you want, but the facts remain the same. You got the card, use it, and made payments until you convince yourself that you could magically erase debt using your trust account, which is just as imaginary as the nonsense you've been reading online. It's sad to see people fall victim to such terrible misinformation, and I'll always speak out against these ideological scams so others don't get trapped by them. A judgment's been entered against you. So do the right thing. Pay your bills and be a decent human like the rest of us. Alright, that's it for today's video. If you enjoyed it, hit the like button. If not, hit dislike. But don't forget to drop a comment below and subscribe with notifications on, so you don't miss any future content.